And sensitive data is your health, political, ethical, racial, and also we have specific regulation.
So imagine that I have a big tennis club. I have a lot of members and very, very good members as well. And then a big sports company contacts me and say, can we send out Christmas cards and gifts to all of your members? And I said, sure. And they also get 10% discount. And then I, as the tennis club owner, get 10% kickback. So I say, yeah, of course, it's a good deal. So I say yes. And I send over all the information that the big company needs for my customers and the members. And one day, one of the member calls me and said, what in the world is happening? And also, thank you, Key Solutions, for having us today. And how could then they get the information? What do I do then?
GDPR.
GDPR, that's why we are here. And the person is very angry, to be said as well. Yeah,
that's typical. Somebody will be mad.
Yes.
Always.
So in that situation, did I do something wrong?
Well, let's have a look.
Yes.
So, we talked about what is personal data. We talked about you as a controller. In this case, the club. You're the one who has gathered the information about your members, decided what information, why, and how it's processed. And before you gather and process that information, you need to identify a legal ground, legal basis for that processing. And you cannot just switch along the line. You need to know before. That was part of the last episode about the 7 principles, fundamental principles that you need to adhere to. The purpose limitation, why are you processing the data? And lawfulness, do I have a legal ground for it?
Yep.
And then we have in GDPR, we have in Article 6, easy to remember, 6 legal grounds. And you need to pinpoint any processing of that personal data to one of the legal grounds. And in this case, the processing will be you sharing the information with this commercial company. So we'll go from the top and we'll come back to your example.
Yes, let's start.
Yeah. We have consent. And this is rather complex. And when GDPR came along, everybody asked for consent for everything. And that's not so good because consent you can withdraw. And in order to give a consent, so it's a legal basis, it's acceptable, it needs to be freely given, it needs to be clear, specific, and transparent.
So that's good to know.
Very good to know. And so, for instance, imagine that I'm your boss. And I say, well, Ida, I want to put in this location monitor in your car. Because I feel that that's very good for us as an employer to just know where you are during the weekends. Can you sign this consent form for me to make sure that you're okay with me monitoring where you drive on the weekends? Well, in that case, it might not be freely given because the power dynamics between us two makes it so that you might feel that you might lose your job, or I might be mad at you, or some other pressure if your boss comes and says, well, we need to do this now.
Yes,
please
so
sign.
It's kind of being forced to do it.
Yeah.
Okay.
So free needs to mean it has no other repercussions if you say no. Yeah. So consent is one. Freely given, very clear. You need to understand what you're giving your consent to. So very clear. It cannot just be pre-filled, long form that you can hardly read, which many tried with. So that's number 1, consent. Yes. Number 2 is quite a clear one, fulfilling a contract. So if you're the tennis club owner and I'm gonna pay you a member's fee every month, then of course you need to process information about me, and that can also be information prior to entering into a contract. Because imagine that you're a car dealer and you want to give me a quotation because I want to know what price, and it will include a car insurance. Then perhaps you need specific information about me in order to give me that quote.
So then, and the next one?
Number 3 will be a legal obligation. So, for instance, you might, for tax purposes, even if I quit your tennis club, I'm no longer around. If I've been paying you monthly fee, you might need to keep that for tax purposes for 10 or 6 years in your jurisdiction. And it's good to know that legal obligation, that needs to be an obligation under EU law or a jurisdiction within the EU. So it cannot be a legal obligation from Chinese law or the US law, because that might say a legal obligation to keep it forever and to share it with the government. And that won't suffice.
Okay.
Yeah.
And the next one.
Which number are we on? We're on
Number 4.
Number 4. And then we have a vital interest. And that's quite a narrow one.
Yeah.
So we won't use that as often, but hear me out. Imagine that when I'm on the tennis court and it's going great, but then I fall over, I trip, and I sprain my ankle and I bump my head and I'm unconscious. Then you might need to share my information with the ambulance and with the hospital, because I'm unconscious, so I can't do it myself. But it's a vital interest. You need to save my life, or at least help me out here. So that's quite narrow, but that's okay.
That's okay.
Yeah, to process data when it's a vital interest.
We're heading over to number 5.
And that would be a public interest. So something that the public authorities, something need to do, or you on assignment from them. So that's also rather narrow when we're talking about us business owners and founders here.
And we have number 6.
And that's quite exciting. That's a legitimate interest.
What can that be?
Yeah, and then we'll do a balancing act. We'll do a test, see what's the purpose of the processing. Is it necessary, the processing? Can you do that reach that purpose with some other means? Because then it will not be a legitimate interest. And number 3, a balancing between your legitimate interest, that purpose, and my interest as a data subject for keeping my personal data as is, my integrity. So that's a nuanced one, and what it can be to detect fraud, for example, but that's kind of obvious, I would say, that can be a legitimate interest. But more interesting is that it can be commercial interest as well.
Okay, and what can that be, for example?
Sharing your membership with a sports brand could be a legitimate interest. As long as it is reasonably expected from your members that this could happen, and you have all of the other safeguards in place, and you do not overshare, this could really be a legitimate interest. So that's very good to keep in mind, that commercial interest can be a legitimate interest, but you need to do the test. Number 1, the purpose, identify. Necessity, number 2. Number 3, the balancing between the two, the individual's interest and your interests. Is it reasonable and reasonably to be expected? And number 4, you need to do a legitimate interest assessment. And that means taking these 3 in the test and documenting it.
Okay.
Show that you did your homework.
So for the example in the beginning, did I do something wrong?
Perhaps not.
Okay.
But there is case law with a tennis club that they did see that this was a legitimate interest. But it will be a case-by-case test, so I'm not going to say yes or no.
Okay. But can it depend on how I send over the information too, just by email or piece of paper and handing over?
And how extensive is it? Is it kids? Is it some kind of sensitive information? Because anytime you're handling sensitive information, you need to have one of these legal bases, and you need to comply with extra regulation. And sensitive data is your health, political, ethical, racial, and also we have specific regulation concerning if you have been convicted of a crime or in some way suspected of a crime. So keep that in mind also. Could it be sensitive data that you need to comply with one of the 6 legal bases and additional demands?
That's really good to know. Thank you so much. Is there anything else that we should think of regarding this?
No, I think that's it. And just remember, you need to define the legal basis before you process the data, document it, that's your best protection. And in particular, if it's a legitimate interest you're going for, do the LIA, that is legitimate interest assessment. Show that you did your homework.
Yeah, remember that. Thank you so much once again. This is an episode from our masterclass about GDPR and data protection, which is a European law. And we're here to share this with you. It's not legal advice, it's knowledge sharing. It's very good to remember.
Only.
So if you have a business, this is really good to know because you want to have a good reputation and do not mishandle information and personal data. No. Thank you so much for today.
Thank you.
Stay tuned because we'll be back as always.
Bye-bye. Bye.